going to call this meeting to order. Bienvenue à la réunion numéro.
Welcome to meeting number 55 of the Standing Committee on Access to Information, Privacy and Ethics of the House of Commons.
It's in a hybrid format pursuant to the House Order on June 23, 2022, and therefore members can attend in the room and remotely using the Zoom application. Should any technical challenges arise, please advise me. Please note that we may need to suspend for a few minutes as we need to ensure that all members are able to fully participate. Conformément de l'article
Pursuant to Standing Order 108-3H and the motion adopted by the committee on Wednesday, November 30th, 2022, the committee is commencing its study on the third edition of the Lobbyists' Code of Conduct.
I'd like to welcome our witnesses today. Ms. Nancy Belanger, the Commissioner of Lobbying. Welcome on this Friday morning. Madame Clerk, pour le bénéfice de...
For the benefit of our interpreters, have we ensured that everyone is wearing the regulation headsets? Sound is good? Yes? Members of the committee are correctly outfitted, and so are the witnesses. They have been checked. Thank you so much. Mr. Vermeer always puts his question to us, and rightly so that is why I am checking ahead of time. I also would like to welcome Ms. Normandin, who's standing in for Mr. Vermeer.
Mr. Dalton and Ms. Koutrakis on behalf of Ms. Khalid. So, Ms. Belanger, the floor is yours. Thank you for being here this morning. Please proceed.
Thank you. Bonjour, Monsieur.
Good morning, Mr. Chair and committee members. I welcome this opportunity to discuss the Lobbyists' Code of Conduct that I referred to this committee on November 15th, 2022, along with a document explaining the changes to it. I'm joined with Scott Waymond, our office's political analyst. As Commissioner of Lobbying, I have the responsibility of developing the code which defines the standards of ethical behavior required of registered lobbyists. It contributes, along with other ethical regimes, to enhance public confidence in federal government institutions. My experience at administering the 2015 Code highlighted challenges in applying its rules of conduct and in providing guidance to lobbyists. In updating the Code, I aim to address these challenges by using clear and plain language, by focusing on the actions of lobbyists without importing the various ethical regimes, and by creating a comprehensive code so we wouldn't need to rely on separate guidance documents to define key concepts.
Of public consultations over a 2-year period. Overall, we received positive feedback on the new code, particularly with respect to the clarity of its objectives and its rules of conduct. I received passionate but widely divergent feedback on 2 issues: political work and the value of allowable hospitality. On political work, the 2015 Code prevents a lobbyist who participated in a political activity from lobbying the official who benefited from this participation and their staff for a specified period. There is no definition of political activity or what is meant by a specified period. A separate guidance document suggests that the cooling-off period for higher-risk potential political activities should be equivalent to a full election cycle. There is no specified period for lower-risk activities, only a recommendation that lobbyists exercise caution if they are frequently involved in such activities. During the consultation, some stakeholders suggested that after participating in important political work, the cooling-off period should be for at least 10 years. While others argued that any such restriction could infringe a lobbyist's charter rights, a concern I shared. The updated rule was carefully crafted to achieve its objective of restricting lobbying where a sense of obligation could reasonably seen to exist and to provide the greatest clarity for lobbyists, all while complying with the charter. The new rule defines and provides examples of the political roles that could reasonably seen to create a sense of obligation. It also excludes from its application certain forms of political participation. The rule does not prohibit lobbyists from engaging in political work, but prevents them from lobbying the official who benefited from this work and their close associates. The rule also sets out a cooling-off period of 1 or 2 years based on the significance of the political work or the level of interaction with the official. When considering other regimes and the 5-year restriction on lobbying that applies to senior officials when they leave office, I believe these cooling-off periods are reasonable and appropriate. I am confident that, as currently drafted, the rule is on solid constitutional footing. I have real concerns, however, that extending the cooling-off period beyond 2 years creates risks with respect to charter compliance, particularly given that the code is a non-statutory instrument. En ce qui concerne l'hospitalité,
With respect to hospitality now, the 2015 code prevents a lobbyist from offering gifts to an official that the official is not allowed to accept. This rule therefore requires the Commissioner to defer to various federal authorities governing ethics of such office holders to determine whether lobbyists can offer hospitality to them. The new rule allows lobbyists to know when they can offer hospitality and the permissible value regardless of other regimes. Some argued that lobbyists should not be allowed to offer any hospitality. Others said having a monetary value added to the clarity of the rules, but some argued that it was too low an amount. Some believed the status quo should be maintained. I determined that a $40 limit for food and beverage, excluding taxes, was reasonable, with an annual limit of $80. The low-value amount is based on federal hospitality standards, recent average restaurant meals costs, and the impact of inflation over the past 2 years. In my view, this view will promote equitable access for all lobbyists and avoid creating a sense of obligation on the part of the official.
Possible to anticipate all scenarios. A lot of thought went into revising the ethical standards that federally registered lobbyists must follow. Mr. Chair and members of the committee, I look forward to your questions, your comments, and would welcome any suggestion to improve the code before I finalize it. Merci.
Okay,
Thank you.
Ms. Belanger. We now are going to move to our 6-minute round of questioning. We're going to start off with Mr. Couric. I will note for the benefit of the committee that I have spoken to Mr. Couric. His flight was canceled, and the only piece of clothing that he has is the T-shirt that he's wearing. So, I just, yeah, well, I'm sure there's more, but Mr. Couric, you have 6 minutes, sir. Oh, you're on mute. You're still on. Something's happening here. Hang on a sec.
Good morning. Can you hear me?
There you are. Yep.
Okay. Thank you, Mr. Chair. For the benefit of the committee, I am wearing more than just a T-shirt, but it's certainly not something I expected when getting on an airplane yesterday, that my outfit would be something that would possibly be referenced in parliamentary proceedings. Thank you, Commissioner, for joining us here today, and certainly I think that the majority, certainly virtually everybody that I speak with, would agree that we need to have a regime that ensures that there's not undue influence put on by those who would attempt to manipulate officials, politicians, and the like to their benefit. But I would ask, one of the challenges, and I went through some recent news stories, including some very, very public examples where there were people who were involved in government contracts and people who were given consultancy fees and a whole host of others. And as I was searching through the lobbyist registry, those individuals' names were not on it. So they don't fall into being registered lobbyists. Yet it's quite clear, in fact, as an example, both the Prime Minister and the Deputy Prime Minister referenced very clearly how a particular individual that's been in the news, Mr. Barton, was recruited because of his contact list. And I'm just curious if you could outline how that right balance is found, because when I searched through the list, these names were not found on it.
Thank you for your question. The question of obtaining contracts is not something that is regulated in the Lobbying Act, except for consultants. So if organizations and corporations hire a consultant to negotiate a contract for them, the consultant would need to register with our registry under the Lobbying Act. However, any communications with respect to contracts for organizations and corporations, it's not part of the Lobbying Act. And that is something that we likely should be looking at if ever the Lobbying Act is looked at and reviewed. I would note that in British Columbia, and you should have a look at that regime, in British Columbia, any conversation that is beyond the regular procurement process that is very much in the public domain requires a registration from organizations and corporations. But right now, that's not regulated at the federal level.
And certainly, it speaks to, I think, one of the issues where Canadians simply want to be able to trust that their officials are not being exerted undue influence and whatnot. So certainly, one of the challenges, and I know you spend a lot of time in the explanation, moving the code to more plain language so that it's more clearly understood, helping to try and find that right balance. And I know you outline in your report how you heard examples from both sides. So can you explain to the committee how this would help build public confidence in the system to ensure that Canadians know that their officials are not facing undue influence?
If I understand your question correctly, how the current code that I'm proposing would help to benefit, or adding contract? Okay. Well, basically, right now, the rules are simply not clear, and because they're not clear, it is very difficult to regulate, investigate, provide advice, and I think adding clarity where, and from the moment I was appointed back in 2018, lobbyists would tell me, the code is not clear. I don't know what I can and cannot do. And so we would issue guidance, but I don't know how I could find someone in breach of a guidance that in and of itself is not very clear. So I'm hoping that we've struck the right balance, considering that I think our code is currently one of the best in the world, and now we're simply going to raise that bar even more by adding clarity. We've looked at what exists in the world. We've looked at what exists in the other provinces, and in fact, there's not too many codes of conduct. And I think, based on the submissions, if anyone takes the time to go look at what's on our website, I think we have struck the right balance.
Thank you, Commissioner. Just wondering if you could provide to us, because I know there's been discussions around the charter compliance issue, specifically around the political campaigning, but I'd like to ask you a question about the actual lobbying. You know, of course, over the course of COVID, $500 billion was spent in COVID response approximately. Have you seen any significant trends that have reshaped the way that you look at lobbying in Canada over the last number of years?
Well, certainly the pandemic has increased the number of communications, and mainly because people needed to be heard, I think, and all of you did open your doors, and so the numbers have gone up and continue to go up. One of the requirements under the Act is to actually enter every time you have an oral and arranged communication. And of course, every virtual meeting is oral and arranged in advance, so that had to be inserted in the registry, and it has gone up. You see every week the issues that concern Canadians are usually the issues that are top lobbied. So whether it's health, environment, and economy, really, are the three usual topics. And so it flows with what is of concern with Canadians.
Okay, that concludes your 6-minute round, Mr. Keurig. Thank you, Ms. Belanger. Next, we're going to go continue online. Ms. Hepner, you're up for 6 minutes.
Thank you, Chair, and thank you so much to the Commissioner for being here for us today and taking all these questions. I'd like to first go back to something my colleague, Mr. Couric, said about consultants not being on the registry. And I'm wondering if you can clarify for the committee whether companies who are responding to RFPs and who are bidding on government contracts are required to register as lobbyists.
So just to clarify, consultants who are government relations officials, if they are hired to negotiate a contract for an organization, so they would have to register. Oh, sorry, but did you?
Ms. Hepner.
Yeah, sorry, I was calling a point of order because I couldn't hear the floor, but I think it's because I was not muted, so I did hear her eventually, but I missed the first part of what you said. I'm sorry. Can you restart my time?
Well, I'm not going to start at 6 minutes, but I've paused it, and I'll allow Ms. Belanger to answer your question, and then I'll restart your time.
With respect to consultants, if they are hired to negotiate a contract for an organization or corporations, they would need to register. Organizations and corporations who follow any public process, and even if it's not a public process, any contracting is not required to be registered currently under the registry. No.
Thank you for that clarification. My next question is around volunteers. I mean, I was just recently elected in 2021, but I think all of the elected officials around this table virtually and in person there appreciate the value of volunteers to the political system. And you need a lot of volunteers. They're really important. And I really feel it's a way for people to get involved at a grassroots level in the political system, to understand it better, to have their say, to just get a feel for it. I think it's a really important part of the process. And I would like to know whether those people would be affected by the update in this code. How do normal Canadians who just get involved and go knocking on doors at election time, is the sense of obligation a factor in those cases, in those basic grassroots political things that we see every day?
The code for lobbyists is only applicable to registered lobbyists. So any individual who volunteers for you who is not a lobbyist is not subject to this code. So it's really only for the individuals that are listed in a registry. If they are registered to lobby and they do volunteer for you, there might be some consequences under the code because they would be subject to the code. And so if there is an appearance of a sense of obligation, because then they'd go lobby you when you know that they have volunteered for you, there's certainly an appearance possibly of a sense of obligation. It will depend what they have done. And, you know, I have the rule to regulate lobbyists, and you've got your own rules under your own code of conduct to ensure that you don't improperly further the interests of individuals that you may know that may have helped you. So, c'est un tout. It's a whole, right? It's from the lobbyist side and it's from the public office holder's side. So it really will depend on the facts of the case and what they have done. And if they're registered to lobby. I mean, that's... Okay.
But in general, it wouldn't be a disadvantage to volunteer for an MP because then you could never go ask that MP for a favor or for help or to be seen to be receiving services that other people wouldn't get from that member of parliament. Would you clarify?
Yes. Well, if the individual is a registered lobbyist, they do need to be vigilant about who they go to help and who they're going to go lobby afterwards. So they should be calling my office. If I can give you a stats, there's been 2 elections since 2010, since I've been in position. There's only been 40 calls to my office about the application of the current rule on political activity. Only 29 of them have been from people who are thinking of playing a role, an important role, and wondering what the consequences. So considering that there's 8,000 lobbyists, that there's over 300 of you getting help from many, the fact that I'm only getting 29 calls about playing an important role, I don't know if it's a prevalent issue, or I don't know if people are just keeping it under the radar, and I just don't know. I don't know. And so I'm hoping these rules will send a signal that they need to be careful and need to call us to get some help.
Very good. I would like to go back to in your statement when you said that Canada's code is among the best in the world. Can you elaborate more and sort of talk about peer countries and what sort of differences there are? I understand that. Anyway, I'll let you answer that question. Thank you.
Yes. In the world, there's about 11 countries that have codes of conduct. And of course, it will depend on their regime. And for the most part, and I've read them all to see if I could get inspired, they're very much principle-based. And very often, the authorities don't necessarily have the power to investigate and regulate. I would say, for example, when it comes to political work, it's actually quite silent. Even in this country, only in Ontario has my colleague suggested that there should be a cooling off period, and it should be for a year. So we are one of the best, and people look up to us. But there's still improvements to be made, and I'm hoping that this is what we'll do. It will do.
Thank you, Ms. Hepner. That concludes your 6 minutes. Thank you, Ms. Belanger. La prochaine, Madame Normandin.
And now we will turn to Ms. Normandin. I recognize you. You have 6 minutes, Madam. Thank you very much, Mr. Chair. And thank you, Ms. Bélanger, for being with us. Much appreciated. My first question is linked to what Mr. Courig has asked you, just to make sure I've understood correctly. Just want to make sure I do. I understand that a commissioner can investigate and even table a report in the House should they feel that the ethics has not been respected. Could a commissioner do so for someone who should be registered on the Registry of Lobbyists but is not? That's an excellent question. Someone who should be registered in the registry and is not. Well, I will investigate. If I have reasonable reason to believe that they should have been registered, I must suspend my investigation and send it to the RCMP, and then we wait for their analysis. If the file is sent back to me, then I can report to Parliament to explain the situation. But would it then be relevant to carry out further investigation based on the code? I haven't necessarily the resources to do that. I would certainly advise that the person should have been registered. But if they are not registered, indeed, this is a breach of our legislative requirements, and I send it to the RCMP. So if there's further material, according to the RCMP, they would send that back and you would have some power there. Yes, I would. I would like to go back to the 12-month, 24-month cooling-off period, how it is decided. I understand that there have been some parallels drawn to the length of the mandates of any government in the House. Of course, in a minority government, it's a shorter period. But has there been any discussion of how this should be studied, perhaps with psychologists weighing in and so forth? What led you to decide on 2 months, more particularly, with regard to the feeling of being obligated to someone? It's 24 months, not 2, 12 or 24, as you said, first time. What we have taken into account is the fact that there is currently a directive to the effect that it should be either 5 years or nothing at all. So we looked at what's being done elsewhere around the world, which is not always very clear or stated. So it's really up to those who are carrying out the lobbying or receiving the lobbyists. Basically, it's up to you to decide whether you should receive this person as a lobbyist. There was the 2015 rule, but I might have said, let's not have any specific rule. Basically, that's what was happening. So we decided to try to specify, to come up with a specific rule. I looked then at all the rules so far. Conflict of interest, a minister who leaves the government cannot carry out certain activities for a 2-year cooling off period. For other situations, it's a 1-year cooling off period. In other countries, for example, you have a 5-year cooling off period. If you leave the House, you're not allowed to lobby. If I compare that to political activities, which of course are restricted in their duration, Let's say you have likely been in the House for 2 years or more. I needed to compare the two, and that's how I came up with the length of time. I didn't hire any psychologists. It's really based on the facts, how long they were a politician, the role that you played, how the extent of your role, the duration then, the prominence. And it's based on that we would carry out any investigation. I understand that it's really the government person who bears the weight rather than the lobbyist, the weight of the decision, but there would be no consequence. Let's say they didn't state that they felt that there was a sense of obligation with regard to the lobbyist. They're not going to be held to account. Well, you could communicate with Mr. Dion, who is in charge of managing your ethics, but it's not even a consequence for the lobbyist, if I understand. Well, there would be. If I conclude that they should not have lobbied you, I investigate and I report to Parliament. The only consequence would be the questioning of their competence and their ethics based on the report to Parliament. I understand that you have received legal advice that there would be potential breach of the Charter when it comes to running afoul of the constitutionally protected rights to carry out political activities. But what about the right to work? Because, yes, of course, there's an effect on the right to carry out political activities, but also that really affects a politician's ability to carry out their political work. So I'm not quite understanding the restrictions on the right to work. Just as politicians are restricted to respecting a cooling off period, how does that apply to their right to work? I understand. I did not address solely political activity. I asked, is there a rule which would prevent people from working? And there are, of course, legal weights attached to that. The right to be involved in political activity, that is not the rule that causes the problem here. It's really the breach of or infringement on the right to free expression, where you're keeping someone from coming and speaking openly with you. The analysis, the way we wrote up the rule, is such that we restrict so as much as possible, so it's very specific situations, the way this limit would be applied to make it justifiable and fair, so that we do not infringe on the right to free expression and to express oneself on the political arena. So it's a very specific application that's allowable. Thank you. Thank you very much, Ms. Normandin. And Ms. Bélanger.
For 6 minutes, sir.
Well, thank you, and thank you for coming before us here today. I appreciate that you've been working or producing this new set of guidelines or rules to provide more clarity, and I guess the problem with that is the more you try to be clear, the harder it is. There's a lot more questions about the clarity on the details, and so, for instance, the new rule regarding gifts in the old rule, and I assume this is replacing the old rule, it mentioned favors and other benefits, but this new rule does not. Is that true? And if that's the case,
no, the definition of gifts would include favors and benefits.
okay,
It's still included.
okay.
Yes.
I'm just.
Yes.
It didn't seem to be there, but so there's no gaps in terms of.
No, if you look at the definition of gifts,
Right.
and we've given a list of examples, it's quite broad. It's really any advantage.
Okay.
Yeah.
Right. And the same thing goes for the definitions of who's a friend and who's a
Yes.
close friend.
There are, yes.
And is that where you expect people to pick up the phone and call you and say, I have somebody who I met at a party 3 times in the last year. Is that person a close friend or a friend? Or
Yeah, Well, it's a good question, and you are all subject to making sure that you're not furthering the private interests of your friends, and I think that is an important. Who is a friend is it's a difficult question to answer, and I do want people to call us so that we can help them navigate. But we have a definition of a close bond. It's, personal affection. We will look at the facts. Do you see this person regularly? And even if you don't, do you call that person when you've got the biggest problem in the world? Like, it really will depend on the facts of each case. And we will advise people, don't do it. And you should always err on the side of caution and not lobby. If you have your own doubt about whether or not this person is a friend, you probably should not lobby them. But we have given a list of definitions and indicators of what we will be looking at, a list of examples to try and guide the lobbyist in making sure that they stay on the right side of the line.
Okay, and so lobbyists, I believe, can request a reduction in the cooling off period?
Yes.
And would those requests be made public? Would those be on
the record?
On the record?
That is a very good question, and if it's something that this committee thinks that I should do, I would definitely consider it. Obviously, there's some serious privacy concerns of getting advice and getting a reduction, and unless it's in my code that I would make those things public, the individual would need to consent. They would likely let you know that they've received a reduction before they would come and lobby you. If this is something that the committee wants me to pursue, I can do that, and I would likely consult my colleague, the Privacy Commissioner, to make sure that I would not be doing anything untoward. But it is a good point, and it's probably a good suggestion, and it would enhance transparency for sure. So I will consider that.
And one final point, again, another detail, you have this $80 limit for
Yes.
hospitality. Much of the hospitality I get from lobbyists, I don't get taken out for lunch very often, but I go to receptions. Everybody here gets invited to
Receptions,
3 or
yeah.
4 or 5 or 8 receptions every night. And is it reasonable for a lobbyist to keep track to who shows up at those receptions and how many, some lobbyists are working for various groups through the year? How do they manage that? And
Well,
I mean, it's good to have that detail, but then it gets kind of unwieldy.
Well, right now the guidance doesn't mean very much right now because lobbyists can offer hospitality, and if the recipient can accept it, they can give it. Let's not forget you're not the only ones who are being lobbied and offered hospitality. The senators are, and all the public servants are. So I am required to figure out who can accept what under what regime. And so by doing this rule, we have now brought it back into regulating lobbyists to all be on the same level playing field with everybody that they lobby. Now, when I hear that it's going to be a burden, it's not that complicated. We've offered a formula. You expect 300 people, you order food for 300 people, you take your total, divide it, has to be under $40. And it's who they offer it to. Whether you show up, not show up, you eat worth $50, someone else eats zero, it's not the test. We're not averaging it out. We are sending a signal that it has to be reasonable. And I see in the news often that there's likely been some, and I'm bringing it back. And as far as I'm concerned, from the lobbyist perspective, the whole hospitality has gone unregulated for far too long, and so we're bringing it back. When I hear from lobbyists that it's a parliamentary privilege that I will be infringing, I have some serious concerns. And so that's why we landed where we've landed.
Thank you.
Thank you.
Thank you, Mr. Cannings. Before we go to Mr. Dalton in the next round, I'm going to use my privilege as a chair to ask a question, and it refers, Ms. Belanger, to the letter that you sent to the committee on December 14th regarding the cooling off period and the legal opinion that you sought. And in it, you said that the Charter gives a low threshold for infringement of the freedom of expression set out by the courts, and that the new cooling off period would likely be justified under Section 1 of the Charter. My question is there anything in previous court rulings or any other jurisprudence that would affirm what that charter infringement would be? In other words, you sought this legal opinion. They said that it would be justified under this part, but not under this part. Are there any rulings that the expert legal opinion could refer to?
So I'll do a charter analysis course 101, but the first test is to examine whether or not the rule as written infringes any constitutional rights. And when it came to freedom of expression, I am stopping people from lobbying for at least 2 years or a year, depending on the circumstances. The courts have said the minute you stop people from being able to speak, it's a very low threshold. The freedom of expression has been breached. Then when you go look at Section 1, is it justified? Is there a reason for this, and has it been crafted in a way that it minimally impairs? And so when the objective is to ensure that we have ethical and transparent lobbying, and that lobbyists do not lobby people that have a sense of obligation towards them, they have said that the legal opinion says that objective is clear, and the way that the rule has been crafted, we're not stopping people from doing political work. In fact, we're letting them do it, but if they choose to do so, there might be limits in who they can lobby afterwards. And it's only the people that they've helped get elected and their close associates. It also is limited in time. And, depending on the facts, it could be reduced. If somebody is your campaign manager and within a week you realize that it's not working and you let them go, they shouldn't be prohibited from lobbying you for 2 years. So there will be some facts that will be reviewed. And according to the opinion, it was crafted in a way that the court would likely simply say that it's justified.
Okay, so you also mentioned you went externally. Can I ask where you went for that opinion?
Well, it's actually in the public domain that I have a service contract with Goldblatt.
Okay.
That's in the public, Goldblatt Partners.
Goldblatt Mitchell, or it used to be Sack Goldblatt Mitchell, but
yes, exactly.
Toronto.
Now, for the
Okay.
record, this is not a law firm that is registered to lobby, and they did a conflict of interest screen, so they're not in a conflict when they provided me with this legal opinion.
Okay. Thank you, Ms. Belanger. We're going to go to Mr. Barrett next for 5 minutes, Mr. Barrett. Thank you.
Okay, thanks very much, Chair. Appreciate that, and we'll have Mr. Dalton take the next set of questions. Commissioner, thanks for joining us again this morning. Can you give us an update about how many investigations that you've undertaken, a total, which is something that's available in your reports? How many have been referred to the RCMP, and of investigations and referrals to the RCMP, how many are ongoing?
I have referred, since my appointment, 11 files to the RCMP. I know that there has been one charge laid, and they have returned 5 files recently to me, which I haven't decided yet what I will do with that. So there's likely 5, 6 still ongoing. Files right now, I have probably 35 open files that are being looked at either at the preliminary assessment stage or at the investigation. It's always around 30 that we have ongoing.
On what's in the news. So we saw with ArriveCan that we had the principals of a company called GC Strategies that were in almost constant contact with senior officials directly related to their field of business. And at one point, even inviting, through, this is again in public domain, through access to information requests, even inviting the most senior person with respect to the business they want to do in IT and technology out to an after-hours party, but constant meetings, constant invitations. Should that be considered lobbying? I mean, that is exactly what, if you walked out onto Main Street in any of our communities and asked someone, if you could find someone when it's minus 40. But on any other day, if you walked out and there was someone there and you asked them, does that sound like lobbying to you? They're going to say, yeah, of course that's lobbying. So
The Lobbying Act has a lot of, I'll reframe it, not all communications with public office holders are considered lobbying under the Lobbying Act. It's considered lobbying by a lot of people, but the Lobbying Act does not cover all of the situations that are in with communications with public office holders. The Lobbying Act needs to be reviewed. I will not say it enough. The last review was in 2012. We skipped 2017. We skipped 2022. It needs to happen. And yes, contracting was not in my preliminary recommendations in 2021 because I simply had not studied it enough. But I have now, and I have looked at the regime in BC, and I do believe that there is a gap in the Lobbying Act with respect to contracting.
right.
For orgs and corps, it's not for consultants, obviously.
Right. What about, we heard in testimony at another committee this week at Government Operations, it was reported in the media that the former head of McKinsey had taken a dinner with the now Deputy Prime Minister at her private residence. That firm has since done significant business in the excess of $100 million with the government. If there was a friendship there and no business was discussed, I think perhaps a reasonable person might say, well, that's not a lobbying interaction. But if the relationship is based only around business, and that seems to be the comments that Mr. Barton has made, even a dinner in a private home would be considered a lobbying effort.
Well, the location right now is not an issue, but it's the communication itself and whatever is discussed that whether or not it would be considered lobbying. Right now, if they're talking about getting a contract for an organization, that is not lobbying. From the perspective of the public office holder, I don't regulate that. So I can only regulate lobbyists that are registered. And when I say registered, I mean those whose name appear on the registry. There's a gap there. Organizations and corporations do not need to register until they've met the significant part of duty threshold. So there is a lot of communication that's happening that is not covered by the Lobbying Act right now. That needs to change.
Yeah, and with respect to that, that calculation, that percentage.
Yes.
Would you say that it's relevant whom is being lobbied? Like if a low-level member of a GR firm reaches out to a backbench opposition member on one occasion, then would that not be different than the chief executive officer of a multi-billion-dollar international conglomerate having direct communication with a member of the Privy Council? So do you believe that the Lobbying Act should treat those interactions
wrap it up
differently?
Quick answer, Ms. Belanger, please.
Possibly. I haven't put much thought to that one. I think any communication with any of you should be transparent, and the level of influence or the level of decision-making power, not something necessarily that should be covered. I think they should all be. All communications should be covered under the registry. It should be transparency by default.
Okay. Thank you, Ms. Belanger. Ms. Sachs, you have 5 minutes and maybe a little extra after Mr. Barrett's interaction.
Thank you, Chair, and thank you, Madame Belanger, for joining us today. These are important questions and things that we definitely need to think about. The government, and I'm sure all my colleagues here, we're committed to ensure that lobbying and federal public office holders uphold the standards that are here, and asking these questions about integrity and also enhancing trust in the regime itself is something I value, as I'm sure everyone here. Previously, the rules surrounding gifts, favors, and other benefits were deferred to other federal authorities. Your office has mentioned that this creates challenges in administering and ensuring compliance with that rule. Can you just go into what challenges your office has been facing with this arrangement?
Yes. Again, since my appointment, 2018, I've received 12 phone calls about receptions, whether lobbyists can offer them or not. They know that even if I say don't offer it, that if you can accept it, they can do it. And so when people do call us and they say, can I offer a $25 breakfast? We usually will say yes. Or if they say, can I give a $50 breakfast? And we will say no. Whether or not that has any weight is zero, because if they offer you the $50 breakfast and you eat it and nobody comes to ask you that you shouldn't have, it goes unregulated. So it is very difficult to give advice right now when I have to rely on all the other regimes. And again, I repeat, it's not just yourselves. It's all public servants who are all subject to different, there is a code of values from the public service, but each department sometimes have their own codes. So it's challenges with respect to certainty. And then how am I supposed to find someone in breach of that rule?
Okay, so going in that direction, under this new
Regime.
proposed regime, you're essentially creating a $40 limit and an $80 annual limit.
Yes.
For gifts and hospitality, and it's a separated limit from what I understood. That this, is it separate, or is it that's the blanket amount for a public office holder in relation to a lobbyist per year?
It's in relation to the lobbyist. They can only offer public office holders, public servants, yourselves, senators, ministers, their staff, $40 per event, per breakfast, and we have asked for an $80 limit. In British Columbia right now, the annual limit is $100. And interestingly, in British Columbia, every time a lobbyist registered, they need to indicate how much money, the value of the gift.
And I want to talk about that because
Okay.
there's an incongruency now. So, it's not the same on all, what
Mm-hmm.
the ethics commissioner had. For example, we all received radon detectors and gave them back.
Yeah.
Because they were valued at $185. So we have this incongruency now. So if it's this amount, and this, it creates a confusing regime, I think, for many folks. Could you comment on the incongruency in the values?
It creates a
Confusion. There's
for lobbyists, it's going to be $40. There is no confusion, and it's $80 annual limit. If this committee thinks I need to raise it to $100, I will consider that. But it's not. There needs to be a signal that, and this is the signal that this is a reasonable amount. And in fact, it's more generous than what public servants can offer to individuals that they host.
Correct.
So I think the amount is, anyway, we came down with that amount, and I think it is reasonable. Not everyone agrees. Some have said that they should not be able to offer you anything at all. And so we came down with an amount that we view as being reasonable.
Okay. How much time do I have, Chair?
You have 45 seconds according to the clock, but with the soccer extra time, you may have a minute and a
We're feeling
half.
kind in -40 weather. I appreciate it. So I just want to move into, if I may, the 12-month and 24-month cooling off periods. As my colleague, Madame Normandin, mentioned, with minority governments, election cycles might look a little bit different. What does this change from the previously defined? How did you get to 12 to 24 as opposed to what a full? Normally we thought a full election cycle here was 4 years. It may or may not be. I come from overseas where election cycles can be 6 months. So, I just like you to weigh in because this is the nature of government today. We may be going to elections more often. So.
And that's why the current rule will not have the concept of full election cycle. It's gone. And it was just in a guidance document, and it was a should, and it was really if you only had a very important role and significant interactions with the person you help get elected. We've gone away with full election cycle, and you're right, in the last years it's been every 2 years. What we did is looked at regimes, and it's, as I say, when we talk about political work, there is really no regime. With respect to political work, the only other cooling off period I could find was my colleague in Ontario, where it's 1 year. Unless, of course, there's an ongoing close relationship, then a different rule applies. But we came down with 2 years and a year, looking at the roles and the different regimes, And the list of the rules are examples. It really will depend on the importance, the relationship with you, the level of interaction. It'll be 2 years, and if it's less, it'll be 1, and if it's not much, it'll be nothing.
Okay. Thank you, Ms.
Thank you, Chair.
Belanger. Ms. Sachs, la prochaine intervention.
And the next questions will be from Ms. Normandin. You have 2.5 minutes, madam. Thank you very much once again. I understand the attorney privilege issue. I'm not going to be asking you for something that you're unable to tell us, but I would like to know whether the legal opinion has been made public or whether it's possible for us to get our hands on a copy of it. I'm just trying. That's a good question. I took for granted that someone would ask it this morning. I've thought about it. I have not yet made a decision. I do undertake to provide you with an answer within the next week. I truly believe in transparency and insist on it. I'm also very aware that client attorney privilege is something of great importance. I don't want to create a precedent, so I'll think about it and give you my answer. Thank you for respecting both transparency and wisdom. Again, about respecting rules, the Charter. I understand that what you've said is that the code is non-statutory, and therefore it might be wise to actually look at the legislation, something parliamentarians can do. Is that a recommendation you would make to the committee, that parliamentarians consider examining the Lobbying Act to perhaps change the timelines there, and it's being up to us to bear the weight of deciding whether there is an infringement or not. You have no idea how happy I would be to be asked to help you re-examine the Lobbying Act. Statutorily, there must be a review every 5 years, yet there hasn't been one since 2012. So it's certainly topical, something that should be carried out. I made preliminary recommendations in 2021. I was asked about this, and I was asked whether I could put this off. I have learned more as I've gone on since then, and I would be ready to provide you with many recommendations for any review you might carry out. If the Lobbying Act were to be re-examined by you, I would certainly be available to encourage you and to provide you with suggestions. Thank you very much. Thank you, Ms. Normandin.
Mr. Cannings for 2.5 minutes, sir.
Well, thank you. There's the accurate information rule in this piece, and I think it's been adjusted to prevent information that has not been reasonably vetted from being used when lobbying, and I'm just wondering what some examples might be. I mean, I hear from lobbyists all the time, and sometimes I don't believe a word they're saying, and I'm just wondering, when can I put up my hand and say
This rule is one that currently exists. We just reframed it a little bit, repackaged it, and I have to say that is probably one of the rules that we had the greatest challenge in framing in the right way, because I certainly can't be the keeper of the truth or of the facts, but in the world of a lot of misleading information out there, I wanted to make sure that lobbyists, when they do lobby you, that have done due diligence and taking reasonable steps to ensure that the information that they do give you is not misleading. So they will have to ask questions of their client to make sure that the information is valid. And of course, I can't breach freedom of expression, and it's not to stop people from providing their opinions, but there is a bit of homework for them to be done. But that rule really currently exists.
So you can't expand on what unreliable is, or?
Well, unreliable would be information that, that they're aware is not accurate. Okay. And I think that's really all I can ask of them, or that I will be able to verify whether or not information is. I don't have the resources to look at all the reports that you are given to make sure that they're accurate and valid and that they're scientific, and so. Yes.
Okay, and just getting back to the 1-2 year piece, just listening to the questions and answers about the election cycles and
Yes.
how unreliable they are these days. Was there any thought to maybe defining it by the election cycle? Like someone who helps you in a campaign couldn't help you throughout that period when you're in office?
It's interesting because lining it up with a full election cycle also doesn't recognize that there are some political activities that can happen when we're not in an election period. So I did not want to actually limit the application of this rule just with respect to election cycles. So we said 2 years for the more important activities, irrespective of, it's from the moment that the activity, the political work stops, and then it would be 2 years from there.
Okay, thank you, Mr. Cannings. Mr. Dalton, you have 5 minutes.
Yes, thank you very much for your comments, Commissioner. We've gone through a difficult time as a nation, with COVID worldwide, and there's a lot of money that flowed to federal government coffers to assist. There was one contract that has received some attention. I appreciate your comments on this one, and it was for $237 million, and it was for ventilators. Ventilators that were, the contract was for twice the much. It was a sole source contract for twice as much as the competition. And so a lot of money. And I mean, the problem with this right here is that the company was owned, a new company at that time, that was owned by former member of Parliament Frank Baylis, who had just I guess, didn't carry on in the 2019 election. He didn't continue. So it was just a number of months later. And I think that I'm not sure how the application of this code applies right here, but we can't, I wonder what your comments are about this situation and his company and even those that worked with him. It wasn't just like, obviously there's a lot of conversations, and there's a lot of money right here and a lot of concern. And he made a quote to the media. He said that he saw an opportunity to help, and he took it. And it seems like he helped himself and the company. And so this is a real concern. So can you maybe talk a little bit about this right here?
With respect to organization and corporations, contract is not in my bailiwick right now. And I think if it is the wish of this committee and Parliament that it be, then the Lobbying Act needs to be reviewed. And therefore, because it's not subject to the Lobbying Act, individuals who do have communications about contract, they're just not subject to my code. Those who will have had this contract are subject, there is a procurement ombudsman. I don't know if he has a role to play in this situation that you may wish to speak to. There's, from the perspective of the public office holders, they're subject to their own regime, but I do not regulate people that have contracts with the government because they're not considered lobbyists at the moment.
Okay, I have another example. It has to do with a lobbyist. I'm thinking of the Aga Khan Foundation, which has received tens of millions of dollars. And I know that this is maybe a few years back, but still, it's some very significant breaches, I feel, were made, and public feels also. And that regards a trip that the Prime Minister accepted with receiving gifts, flights, with all sorts of benefits. And I wonder what you can comment on this with regards with the new code, how this applies.
So any organizations that is registered to lobby, the individuals that are listed on the registry would be subject to this code of conduct. The Aga Khan is not someone who's registered to lobby, and therefore he was not subject. And this matter has gone to the courts, and it's done. But he was not a lobbyist, and mainly the Lobbying Act applies to people that are paid. So you need to be an employee of an organization, or you need to be paid by a client. So currently, volunteers are not included in the Lobbying Act, and that is another issue that we could discuss if the Lobbying Act was ever reviewed.
Okay, yeah, the foundation itself is a registered lobby, just to comment on that.
Yeah.
Now, this is the code is non-statutory, so it's supposed to complement the Lobbying Act. So what teeth does the code have?
So the teeth is that lobbyists are supposed to comply with it, and I am supposed to investigate when they don't and report to Parliament. So the teeth right now is reputational. It is a report to Parliament about someone who will have breached the code.
Okay.
That's it.
So reputational.
Reputational.
Okay.
Yes.
So I'm going to, throw you a softball question, and
Very,
that is
very quick one.
Very quickly.
Yeah.
So-
And
very
what
softball.
element or aspect of this new code would you see as you most want to highlight as far as the benefit? If you can pick one thing that is most
If I had
you're
to-
most proud of, or you think that is the best.
It's all very good.
Oh, very good.
I think I'm extremely proud of my team who has worked on this very, very hard. The client services people who work with lobbyists on a day in, day out will appreciate these rules. And I think it's for the clarity. I'm actually proud of the process. We've listened to people. We have looked at everything. We have come down with an excellent code, which I'm very proud of. So I can't pick one thing except for its clarity, possibly.
Thank you.
Okay, thank you, Mr. Dalton. Mr. Fergus, you have 5 minutes.
Monsieur le Président, puis merci beaucoup, Madame.
Thank you very much, Chair, and thank you very much to our witness for being with us here today. I have 2 questions. Much like many of my colleagues, it seems that we are addressing 2 principal concerns of ours. The first, about the annual limit of $40, and second, the rights that are constitutionally protected, the rights and liberties to participation, political participation of Canadians, and in this case, Canadians who are registered lobbyists.
Where probably reasonable people can disagree. But let me come in on the $80 question first. I love the idea of putting a $40 limit or whatever limit you want to put per interaction for hospitality for members of Parliament. I think that's very important. As a former lobbyist, I think that allows us to avoid the les déboires.
The excesses.
Si on veut pas avoir des personnes qui vont
If we don't want people offering méchoui parties with golden objects passed out to guests and so on and so forth. So I think this is a reasonable approach that you have adopted. So do I. Yes, we agree. That said, here's my concern. Evenings, receptions that may be organized with sector representatives. For example, let's say you have a sector, an industrial sector or otherwise an activity sector representing a number of members. Let's say public universities across Canada. There are, 96 of them, 96 members of that organization. Let's say they organize a meeting, an evening to meet and gather, and MPs will drop by to speak to the chairs of universities in their ridings and so forth. It's very helpful. I'll be able to chat not only the dean of the institution in my riding, Université du Québec, for example, but I can also interact with others so that I can understand what's going on in that sector and be able to better represent my own constituents. My concern is that we'll be forcing universities to speak solely to specific people or certain, meeting people one by one rather than giving people a chance to gather together and really learn something. It's of higher value to myself and for them as well, I'm sure. Wouldn't it be wiser to simply state that per interaction we have a $40 limit? End of story. But if you receive a specific person, a company, an organization, if they get in touch with an MP 5-6 times a year, that's not reasonable. That's no longer reasonable. Would it be better to set a limit per interaction rather than capping, the year? Just have a guideline that would prevent excesses. Good question, but I'm not convinced. So far, the issue of hospitality just hasn't been regulated. Simply put, a $40 limit is a $40 limit. We have brought in the maximum $80 limit. If they want more than 2 receptions, then they'll have to restrict how much they spend per reception. The limit is 40, but, they could spend less. Fine. Forgive me for interrupting you, but my daughter has just been married a couple of months ago. And I know, for having paid for the reception, that $40 is, you don't get much for $40 these days. That's true. It isn't much, but it sends a clear message. If civil servants are able to provide that amount of hospitality when they receive people from off the hill, then I'm not sure why lobbyists shouldn't be held to the same amount. I understand that organizations like large gatherings to meet as many people as possible. They will have several members coming to see them, and they have members of their organization who come together to carry out a reception. They can nevertheless make a request. There is the possibility of an exemption if they speak to us to explain the cost, explain who shall be invited. That's a possibility. I'm not sure what the best solution is. I cannot take for granted that I will receive reports saying, look, this lobbyist has taken me out for lunch 5 times, of course, $40 each, but now it's the 5th time. I don't receive that kind of information. I see it in the newspapers. So I'm not sure where to go with this. If the committee has suggestions, of course, I'll be happy to hear them.
We are, and I apologize, but we were over on the 5 minutes. Merci, Madame Belanger. We're going to go to the next round. And we will start with Mr. Couric. And before we do, I'm just going to remind committee members as well. You've held off on posting this in the Gazette as a result of this committee request. We sent a request subject to having you appear before the committee. So I want that to be kept in consideration as we move forward because obviously the delay in posting it has resulted in a delay in the implementation of the new rules. There may be a desire on the part of the committee to either provide some recommendations, further recommendations to the lobbying commissioner as a result of this meeting, or in fact, as we discussed the other day during our committee business, that there is interest in this and there may be other witnesses that may appear. So in that backdrop, Ms. Belanger, at the end of the meeting, maybe give us an idea of what the game plan is on your side in terms of publishing it in the Gazette, what timeline you're looking at, and what are the reasonable expectations of the committee as to providing some input as a result of this meeting or other stakeholders who have shown some interest in this. So we are going to move to a next round, and I'm going to go back to Mr. Couric for 5 minutes.
Thank you very much, Chair, and thank you, Commissioner, for all of your testimony today. One of the challenges I think that many Canadians have is that it seems like, especially when it comes to some of the headline-grabbing subjects like the conflict of interest and ethics conversation, is that no number of rules seems to stop, whether it's the Prime Minister having been found to have not been compliant with the act, or other cabinet ministers. No number of rules seems to stop those who would endeavor to circumvent them. So specifically when it comes to the Lobbying Act, one of the very troubling aspects of the testimony that I've heard today is the number of interactions And you talked about there being very, very few people that actually reach out and ask for advice. How can we make sure that this is not only a subject of conversation that dominates headlines when the rules are broken, but that we can create a climate where there is more transparency, more accountability, and ultimately better trust built in our institutions around the act of lobbying?
Well, thank you. Well, I can only comment from the perspective of the Lobbying Act. One of the greatest aspect of the Lobbying Act is the registry. And so there is a lot on that registry. It is transparent, but not everybody needs to go on that registry, and therefore there is definitely a gap. And it is a concern of mine that there is a lot of communication happening that's not covered by the Lobbying Act. So it needs to be fixed. With respect to the code, I am really hoping that this will set a new bar on the gold standard in which we do expect people to abide by it, and the clarity will give me the teeth to actually be able to investigate and report on it. And so I am hoping that it will have a positive impact on exactly that, on the trust that Canadians can have with respect to ethical lobbying and transparent ethical lobbying. You know, I would note that it would appear from the media that many of you have been lobbied about this code, and none of it has found its way on the registry. So I don't know who has spoken to you about this. I'm suspecting it's the same people who provided submissions, but that's a problem. Not sure what I'll do about that problem, but it is a problem right now. So hopefully the code will help. So
the comment was made earlier about, a difference between somebody who speaks with a backbencher or an official, maybe even an official reaches out for clarification about something that was said in a previous meeting. Like, there's a big difference between, that and somebody who is asking the government for, $1 billion contract. So I guess my encouragement is less of a question, but is to try and find a pathway to ensure that we can develop, the culture of transparency, which has been talked about in the entire system, but also make sure that, the text messages or phone calls from that seem to be helping determine who gets contracts, that is certainly dealt with. The issue of political activities. All of us around this table are certainly very familiar with political activities, from door knocking, phone calls, and putting up campaign signs and whatnot. Can you just outline, for the sake of those who are watching, what your experience in terms of coming to the position you did in your proposed rules, where you're trying to find that right balance? Because for somebody who comes and knocks on a few doors a couple of times during a campaign versus somebody who would try to do so to influence a public office holder, there's a pretty big difference there. So I'm wondering if you could outline a little bit as to how you came to the conclusions that you did.
We received over the years, looking at different roles that people play in campaign. And of course, we only give a list of examples because I'm not the experts and people have different titles. We came to the conclusion, and again, with the charter backdrop, that with respect to people that are knocking on doors, they should be allowed to knock on doors. However, if they're not knocking on doors with you, the elected official, on a daily basis, it creates a different relationship that the person who is doing it. A former MP had told me once, I don't even know who knocks on doors for me. And I get that. And therefore, that would likely not cause a sense of obligation. This rule is to send a signal for people to call us if they're not sure. But so there is a difference, and I'm hoping we have identified that difference in the list of different types of activities. The second category being people that have frequent interactions with the person that is seeking to be elected. If that doesn't happen, then really there is no cooling off period.
Okay, thank you, Mr. Couric. Thank you, Ms. Belanger, as well. We're going to go to Mr. Fergus. I understand there's an agreement among the parties that this will be the final round of questioning, and then I may have some comments after that, Ms. Belanger. Mr. Fergus, you have 5 minutes, sir.
Thank you very much. And please don't interpret this as being a lack of interest. I think we could have you here for several hours. My second question is regards to the charter, you know, as you know, the legislation. You know, there are fundamental charter rights to participation, Section 3 of the charter, and you are looking and you think you've found a way that has a minimal impact upon this. But yet, you know, I sort of come from the belief that if we're going to limit Canadians' charter rights, then we should do so through legislation. I'm a little concerned about doing this through codifying this without having that larger public debate. With all due respect to the consultations and the extensive consultations that you had organized. You know, I'm trying to. This really comes down to the soft part as to what is a significant influence and what isn't, and I think we need to be very, very careful about limiting people's charter rights. There are a lot of, you know, we have this idea that lobbyists are, you know, these evil folks. I think they're just people who are trying to help organizations. Some do a lot of work, great work for NGOs, do a lot of great work for people who don't normally have a chance to have a voice, to try to get the attention of MPs and legislators and public office holders who are, you know, all over the place. Do you think that it would be a better move to have this part of, rather than having this changed through guidelines or having it codified through guidelines, to have it done through legislation that is actual changes to the Lobbying Act so that Parliament could have an opportunity to discuss this?
Certainly, if you tell me the Lobbying Act will be changed in the next few weeks. That's not going to happen, and I need to find a way to regulate what's going on now. Now, currently, there is already a rule in place, and it's been there since 2015. And so now I'm trying to l'encadrer in a way
Frame it.
meets charter obligations. You know, when you think about it, I could have one rule. It simply says, do not lobby anyone that has a sense of obligation towards you, and leave it at that. Now, I will get a lot of complaints in my office, which I will not be able to get through because I've only got 28 people. And so this is to try and, you know, explain so that we are trying to limit when and how based on considerations, and people should call us, and if they call us, and we will be able to give them proper advice. And let's not forget, you have your own obligations. If you feel like someone, I don't know, if a campaign manager helps you to get elected and they come and lobby you after the election, is that appropriate? And we're saying that it shouldn't be happening if we want to enhance public confidence in the decision-making process. That's why we've limited. If it should be in the, and if this committee believes it should be 5 years.
Sort of a sign chair.
Sorry?
A sign chair, a person who's responsible for putting up or coordinating volunteers to put up or repair signs that are damaged during an election. Should it be,
That would likely
should be a volunteer coordinator?
That will not be, there will be no prohibition for that person. Of course not. We've created a list of those that we thought would have more importance, high-profile work for you. Another list of people who interact with you on a daily basis, and everyone else, there is no prohibition. If people are cleaning up the signs, they will be able to lobby you the next day.
Right.
So there is a nuance, and we try to provide examples of where that nuance will happen. And it will be a case-by-case basis.
I still, you know.
And I hear you. It is a serious issue, and I have known from the moment I was appointed that this was a serious issue based on the guidance document.
Because it would seem to me that the most important aspect of it is the transparency aspect.
Absolutely.
That is what we should ensure, that people know what's going on and who's speaking to whom. That would be, to me, the primary aspect of it. Everything else is variations, as you said. It's a process of evaluation, which makes it really tricky to do. Some people would qualify to fall into that strategic role, and some people wouldn't. So that's where that unfairness or that arbitrariness comes in that just makes me feel uncomfortable.
It makes you feel uncomfortable. And I can tell you, if someone calls my office and says, this is the role I played, and I'm not sure where they fit, I will call you. I'm not shy. I will call you and say, what did they do for you? And do you think it's the right thing? I much prefer preventing than having their name on their registry that they're lobbying you, and then it's on the first page of the news that they've lobbied you when they helped you and had an important role for you. So it is tricky, and we are hoping that we can have conversations with lobbyists and with you and say, look, what do you think would be, and then we will determine the cooling off period from that front.
Well, just one comment to you, Mr. Chair.
Sure.
I would like to, and you've mentioned it, and I think the statement that you made just before we entered into this round is important. I would enjoy having that conversation before the regulations are or the new regulations are posted. I think this has been a question that has come up from all parties, and all the rounds of questions that we've had is to explore this a little further. Okay. It's a very important one.
Yeah, and I think I'm going to leave a little time at the end so that we can discuss that with the lobbying commissioner, Mr. Fergus, just in terms of those timelines and any potential future input as well. So, okay. Thank you. Madame Normandin, vous avez...
Ms. Normandin, you have the floor for 2.5 minutes. A little more, if you wish. Thank you. If the answer is longer, I will ask you to provide our witness with a little more time to finish what she has to say. So we've touched on prevention and on rapid intervention. I'd like to hear more about this. I imagine that the more difficult cases aren't about those who come to speak to you and ask questions. I'm sure these people are trying to respect the code. At the other end of the scale, I'm sure that we see things in the media, McKinsey and other companies, large files that are of interest to the public, of course. When you are called on to carry out an investigation, where do you receive your information from? Only the headlines, or do you have other sources of information? And are your resources sufficient to be able to dig out the problems before they make it to the headlines? Do you have enough staff to be able to carry out preventive interventions? Upwind, if I can put it that way, before things get to the newspapers and to the courts and so forth. All right. No, I don't have sufficient resources. I have up to 33 staff. We're usually clocking it at around 28. I've made a budget request for another 7 in order to be able to raise awareness, fulfill that part of my obligations in order to increase prevention. As for investigations, no, of course, media, these essentially are allegations. We all see these, but I don't chat with journalists. Our most useful witnesses are you, office holders, public office holders, people with whom lobbyists interact. If you haven't received a letter from me, I may indeed send you a letter one day asking for information, documents to the effect that you have had discussions with such and such a person, and then I will interview you. So it is indeed public office holders as well as civil servants, ministers, deputy ministers, who are our witnesses, along with the documented information that they have. They are the people with whom the lobbyists interact. So that's where I get my information. And, of course, your calendars. Who did you meet and when? Thank you very much. Ms. Normandin, are you through? Yes.
You have 2.5 minutes or more.
Okay, thank you. I'm not sure if this is a fair question, so feel free to answer it as you will, but you've referred several times to that it would be good to have the Lobbying Act reviewed. I'll just frame it this way. If you were an MP who were drafting a private member's bill on updating the Lobbying Act, I don't want to get in, you don't have to go into details, but what are the areas that you would concentrate on? What are the most important places to really fix things?
Well, the first one would definitely to close the gap on the significant party duty threshold. For organization and corporation, there's a threshold to be met in order to decide whether or not they should register. We need to eliminate that. So that's the first thing that needs to go. Monthly communication reports is when individuals need to put in the registry that they've had an oral and arranged in advance meeting. And so therefore communications that will happen anywhere else that weren't arranged in advance do not need to make it to the registry. That's a problem. And the other area would likely be the spectrum of sanctions, because right now we've got the code, and if I issue a report to Parliament, there's a reputational thing. Anything else is an offence under the Act, and that is the RCMP. And there's nothing in between. So I would like to be able to have the opportunity to give monetary penalties, prohibit someone from lobbying, issue mandatory orders of education, which I do. I ask them to show up when there's some issues, but that would be probably the top three that come to mind.
Okay, thank you.
Okay, thank you, Mr. Cannings. Thank you to all members of the committee and Ms. Belanger for today's session. That concludes the formal part of our meeting in terms of questioning. But I did sort of preempt a little bit, Ms. Belanger, at the beginning of this round, the timeline for publishing the changes or the proposed changes to the Lobbying Code of Conduct. So if you could just, for the benefit of the committee, tell us what your thoughts are on where you're going to go with this. We would appreciate that.
Well, the first thing I will say is that I have very much appreciated this conversation. I was hoping you would invite me because I'm very much about public discussions and transparency. So I appreciate that you have taken the time. I have seen that you have a busy schedule, and therefore I'm really happy to have been able to have this conversation with you. Now, we've been doing this process since 2020. We have been looking at this a lot and have spent a lot of time for over 2 years. There's been 3 rounds of consultations. I have looked at every comment more than once. It's time that we need to do this code, because for the longer the current code is in place, the issues continue. I was hoping that, and it was in my departmental plan, in my annual report, that I wanted this code to be in place before the end of this fiscal year, which is March 31st. And I completely am aware that that does not give you a lot of time. I would ask the committee to do a SCP, because I really want this to start, to be enforced. The code makes reference to calendar years, and therefore it would have been nice to have as full of a calendar year as possible. But if that's not doable, I am hoping, end of March, April 1st, that I could do this. But I will not proceed on this until I get your sense that you are, that you do not have recommendations to make, or and if you do have recommendations to make, I will wait for them, but I would really ask you that we do this as soon as possible. You may hear from witnesses. I will listen to see if there's anything new that comes up that I'm not aware of, because I really want to get this right. It's not a question of going ahead with what we've proposed, and if there are some improvements to be made, we will make those improvements. But we've stretched, we've stretched where we can based on everything we have heard. So I really am in your hands, but I would really beg that we work on this as soon as possible so that we can move on to something else. I think our team wants this to move along.
Okay, well, I thank you for that, because based on the discussion today, there may be some further discussion, as Mr. Fergus implied, that may have to occur. I don't think it's unreasonable to expect that the end of this fiscal year, which is March 31st, is a reasonable timeline in order to publish these. So I think it's safe, and if I'm wrong, please let me know, that on behalf of the committee that we ask at least until the end of the fiscal year that these be published. If that's your goal, I don't see that as an unreasonable timeline. That'll give the committee time. It'll give, based on today's testimony and today's questions, perhaps outside stakeholders an opportunity to provide input as well. Sure. If there is new information in there, as you say, you can consider that as part of it. The problem that we have as a committee, and we discussed this the other day, is we've got now 29 meetings left before the end of the year, and there are several issues that we are dealing with, not the least of which is access to information and others. So I am going to make that request. I can do it formally in a letter as well. If it is the will of the committee to ask that at least until the end of this fiscal year to consider holding off on publishing this in the Gazette, and that will allow committee members an opportunity. So if that's reasonable to you.
Can I make a tweak to that?
If you can make a suggestion
if I can make a suggestion, if you only provide me your comments by March 31st, I need to Gazette, and then it would not be able to be enforced until sometime in the summer, which is not ideal.
Right. Well, that was my next point. Okay.
So and that I need to publish.
You know, perhaps going around the table and asking committee members what is a reasonable timeline on their part to provide you with some suggestions that you may consider. Mr. Fergus, I'll start with you. Is a week, 2 weeks, 3 weeks? What would you consider as a reasonable timeline?
I don't know.
Okay.
I'm trying to. I want to be helpful. I just don't know. I think, like you said, on the outside for March 31st for sure. Mm-hmm. I think we'd have to have a discussion about committee business as to, where do we want to focus our concerns, and then who would be appropriate people, if necessary, to go outside of this table.
So I'm canvassing the room here, Mr. Barrett. What's a reasonable timeline to expect input from committee members?
Again, it would depend on the tempo of our next few meetings, and we have. I mean, before the end of March, there are 3 non-sitting weeks. Is that correct?
Yes.
Yeah. So that will impact it as well.
Okay. So
I want to provide. It would be great, Chair, to find out from the Commissioner. If April 1st is her target to be able to publish, by what date would she need to receive that feedback for it to be for her to be able to process it and then incorporate it if that is her decision, and then let's see if we can do that instead of 3 weeks, 4 weeks, 5 weeks.
It's a reasonable question, Ms. Belanger.
So if I want this code to be in force on April 1st, it needs to have been gazetted before, and then I need to consider, and I really do want to consider your suggestions. Depending on the extent of this, I may end up having to say it won't be April 1st because you may have a lot of suggestions to make that I need to consider. We need to draft them and then proceed. I do want to give time to lobbyists to adjust to this new code and make sure that they've got time to force. So, I mean, ideally, you would give me your comments by March 1st. It gives me at least a month, but that then gives you less than a month as we're February 3rd. So if you're able, at least if you were able to tell me whether or not you will have suggestions by March 1st, that will help me to then just figure out the timelines from there. Because if you don't have any, then but it will take you time to formulate those suggestions as well, and it does take time, and I'm not trying to rush.
I appreciate that. So based on a discussion I had with the clerk, we may have some time to deal with this at our Tuesday meeting next week, this coming week. Okay, we may have a little bit of time at the end of the meeting to deal with that. I would suggest that perhaps we deal with this under committee business on Tuesday. That'll give you the weekend to think about the testimony that we heard, suggestions, input, etc. Does that sound reasonable to members of the committee? Okay. Madame Normandin, avez-vous un commentaire?
Ms. Normandin, you have a comment to share? Well, as that we will be discussing it in committee as a housekeeping item, I don't want to speak for René. to deadlines. But then the question will be how long each of the members needs to at least provide recommendations to the committee, and then see how much time the committee will need to work through the recommendations. And so I'll leave that to him. Thank you.
Have any comments at all on this, since we're going around the table?
Well, again, I'm not a regular member of this committee, but if the committee is going to be discussing this on Tuesday, I would hope that we could provide some feedback to you by the end of the month, but probably not before.
Okay. Well, given the understanding, Ms. Belanger, of what the timelines are, a clearer understanding, I think the committee can provide its input at a minimum by the end of the month. If committee members agree, just leave it with me for Tuesday. I might be able to fit in a little bit of time to deal with this, and we'll go from there. Okay. So, is that okay, Ms. Belanger? Okay. Good.
Most enjoyable.
And that is all that I have. Not seeing any more business. Thank you, Ms. Belanger.
Thank you.
And thank you to Scott.
Yes.
Who was
He's my moral support.
who was chomping at the bit to get in. I see you shaking your head. No, you weren't. And thank you for coming in and providing your time to the committee today to explain the proposed changes. That's all the business that we have. Stay warm, everyone. Have a great weekend, and we'll
Thank
see you on
you.
Tuesday. Meeting's adjourned.
Thanks, everybody.
Thank you.